All right, 25 minutes before 11 o'clock. It is time to have your questions about the law answered. Right now, this show is called Legally Yours. John B. Fuller is your host, and he's in the studio today on Wednesday, April 23rd, 2014, to answer your questions. If you have a question, the phone number to call is the WOCA Climate Control Source Hotline, which is 622-9622. If you're watching on the internet and you're out of the area, let me make sure you know the area code. It's 352. So 352-622 WOCA is the phone number. 352-622-9622. Your calls are important. Don't let the fact that I may bring up a topic and get John engaged in a conversation stop you from calling. I will shut up and allow you to ask your question. John Fuller, again, your host. He is an attorney here in Ocala at the law firm of Fuller and Fuller. Good morning, John.
Good morning, Larry. Good morning to the folks who are listening. It's great to be here. And like you say, if we start talking about a topic, this is things that may be of interest, that are current news events or things. But this show is designed that if individuals have legal questions that they'd like to have discussed, it's hard to give definitive answers to generalized statements on a show like this, but it may be helpful in discussing the general principles of the law. And then if someone has a particular case or claim or case question, we're always happy to see them. Our law firm, Fuller and Fuller, does civil litigation, complex family law, but we do on a specialized basis, or at least on a restricted basis, and Social Security disability cases. So those are our areas where we focus our practice in. I'm board certified in civil trial law and business and commercial litigation. So those are the areas that I primarily specialize in. But we're certainly happy to see you at the office if you have a specific case, if you've been in an automobile accident or otherwise had serious injuries as a result of some other type of accident or incident. We certainly be happy to talk with you, that sort of thing.
The normal person who is the law-abiding citizen, he is the perfect citizen, and all of a sudden he and his wife are saying, I think we were taken advantage of. And a friend says, why don't you file a lawsuit? No, that's not our cup of tea. We never do that. They finally convince them to do that. What is that like from your end of it? Because you do it every day, and now they're doing it for the first time ever in their lives. That must be a learning experience for them.
Well, yes, it is. The courtroom and the legal system is a foreign environment to most folks.
Yeah.
It's like the first time, hopefully this didn't happen to you, but the first time a person has to go to the hospital to have surgery. It's very intimidating. It's a scary, fearsome place. And so is the courtroom, because you can't totally predict or control what happens there, and you are basically putting your life and the issue that has affected your life in the hands of strangers, and trusting them and the system and your representative to explain the facts and argue them in compliance with the law in a fashion that's consistent with what's in the client's best interest. So yes, but lawyers, the first task that a lawyer has is to do his or her own independent evaluation of the case and investigation of the facts. And they have a duty not to bring a baseless or frivolous lawsuit. It doesn't mean that you don't have a right to bring a lawsuit that may not be something that is ultimately a case that is won, but it has to be not a frivolous or baseless claim. The other thing that is extremely important that people need to understand is that litigation is expensive. And it's time-consuming, and it's frustrating, and you have to evaluate the cost-benefit, just like doctors when they treat a patient and they prescribe a medication. There is a trade-off of risk-benefit because there is no perfect lawsuit. There's no perfect case. And so you have to then evaluate what am I going to be spending not just in the way of legal fees, but court costs, expert witness fees, subpoena fees, witness fee, all the attendant expenses that go into investigating and developing the case before you even get to trial, so you can present the facts to a judge or a jury. And it may well be that people have very good cases where they have been wronged, and there's no question that they were wronged, and they have been hurt as a result of that. But when you look at the magnitude of the injury and damages and what you can prove compared to what it's going to cost to do that, it is sometimes a decision that needs to be made that this is not a case that should be brought.
Now, in the car accident I had no money out of pocket at all. The settlement is what paid for my legal fees. Is that typical?
Yes. In automobile cases, slip and fall cases, we talked about tort cases, negligence cases. The average individual does not have the adequate funds and resources to hire a lawyer, and especially if you're injured so badly you can't work at your job and your income stream dries up.
Yeah.
So what the Supreme Court and the legal system has accepted and acknowledged is a contingency fee contract. It has to be in writing. It is approved by the Florida Supreme Court, and lawyers don't get paid if they don't make a recovery. If they do, they get a percentage.
Okay, and I know you will discuss that at greater length when
we have a
somebody
call.
Comes into your office. Yes, sir. Good morning. You're on the air with John.
Good morning, Mr. Fuller.
Good morning, sir.
I have a question in regards to, and you're right about that surgery. I've been through that recently.
Yeah, it's pretty scary.
But I have a question about class action lawsuits. Specifically, I understand that they're going to be a lot of litigation makes the class action lawsuit in regards to this General Motors ignition problem that they had throughout the years. Now, is there a system whereby in those type of suits, say someone lost their life as opposed to somebody just being inconvenienced by the bad ignition and all that, is there a degree of compensation that a person receives based upon the damages that they incur? I'll hang up and listen to your answer.
Well, as always, your questions are very, very, very profound and very interesting. Class action lawsuits are a specialty type case unto themselves. They fall under the rules of civil procedure, but they have their own separate rules. And before you can be a class representative or a participant in a class action case, there are certain conditions that you must meet, that the case must meet, before it would have the possibility of qualifying as a class action. And if the facts seem to warrant that, you file an action, you make the allegations. The first thing that takes place usually is there is a hearing before a judge who determines whether or not the class lawsuit meets these criteria, and then he has to enter an order certifying the class. And if you don't meet that, in other words, if it's not, and I won't get into the technical aspects of it because it is quite involved, and you could teach a whole course in law school on it. It's beyond the scope of this program. But one of the questions is, are there sufficient people in the class who have same or similar type injuries so that they can be calculated based upon the similarities of the injuries? And if they're dissimilar in nature, it may not qualify as a class action.
Oh, wow. And you do have another phone call. Good morning. You're on the air with John Fuller.
Good morning. I have a question about an interesting legal matter that's been in the news. Mr. Pretorius, that Olympic athlete in South Africa that shot his girlfriend, and he's on trial now. It was revealed that he has been taking acting lessons to prepare for his testimony. It was just released in the media right in the middle of the trial. And I'm sure that witnesses and defendants, rehearsed their testimony to a certain extent. But, Mr. Fuller, what do you think the impact is going to be on the jury when this information is revealed? And I know it's difficult to predict how a jury will react, but I just wanted to hear your opinion on it. Thank you, sir.
Well, first of all, I know nothing about the details of that case, nor about the laws of the country where that case is being tried. I believe, from what I've read in the media, that you are not accurate when you talk about a jury, because they don't have a jury system. It's only a judge that is hearing it in that country. So that is a huge difference from our judicial system, which is based very strongly, and I think very, very appropriately, on a jury system, that you have a right to have your fellow citizens decide your fate. I don't know what their rules of evidence are either, but because an individual may read something in the press or hear it on television or see it on TV, hear it on the radio, that doesn't mean that that is admissible evidence that would even be mentioned in the trial. And we've heard many, many high-profile cases where there was stuff in the news and the talking heads, the so-called gurus who come out of the woodwork and get a job on television, waxing eloquently about what's going on, and sometimes I think talking down to people and not respecting the innate intelligence of the American public when they get on there and try to do it. That happens, when they are hearing things that aren't evidence. So I don't know whether this would even be admissible in evidence in the trial. In American evidence, Florida evidence, we have an evidentiary rule. It's Rule 403, 90.403, which says that even if some relevant evidence has some probity value, that has to be weighed and balanced against the inflammatory nature of it. And would the evidence be so inflammatory that it would outweigh the probity value? And, there's a lot of questions about it. You're right. A lawyer has a job to prepare his witnesses. The truth is the truth. But I've often heard people say on television when they were talking about a trial, well, he looked guilty on the stand. Now, I ask you, for Lord's sakes, what does guilt look like? How do you know that he's not scared to death because he's sitting up there on the witness stand with his whole future before him?
Right.
And so what makes somebody an expert to say he looks a certain way? And so there's a lot of preconceived biases and prejudices. It's like if you shake hands with somebody and he doesn't give you a firm handshake, there's an old cliche that person may not be trustworthy. Well, he may have nerve damage to his hand. It just is hard to make these generalizations.
Oh, yeah.
So I don't know what Mr. Petrosius, however you say it, has done or hasn't done, or what impact. I know from my own experience in big cases, we will try that case to a mock jury, where our consultants go out and hire people, random people, and pay them. We fund it, and they bring them in like on a Saturday or whatever, and you put on an abbreviated case before them, and they listen to the critical points, and then they retire to deliberate. And while they are doing that, they are being videotaped with surveillance cameras that they're unaware of, and you hear what they say about your case, about your witnesses, and about you. I had one case that I was co-counsel in, and the lawyer who was doing it, absolutely brilliant lawyer, experienced lawyer, but the mock jury said, that fella doesn't have any fire in his belly. I don't think he believes in the case, and if he doesn't believe in the case, we're not going to give that person any money. And the other lawyer, who was also a colleague, who was playing the defense lawyer in it,
right,
who had the much weaker side of the case, he had great aggressiveness and assertiveness and brought passion to his arguments, and that impressed that mock jury
Wow.
more than the facts did. So, and neither one of them were acting. It's just that one of them was a very experienced, assertive trial lawyer whose that feature of his personality came out in the mock trial, and the other person was less assertive, and the mock jury wasn't impressed. And so then you go back and you fine tune. Well, maybe lawyer number 2 ought to take a better lead role when you get to the real jury, and lawyer number 1, who has 135 IQ or something, but is soft-spoken and shy and timid,
right,
and maybe not appealing to.
That makes sense.
Maybe he ought to sit there and do the paperwork.
That is fascinating. And you do that every time?
No, because
okay.
It's expensive as the dickens, and you can't afford it every time. But when it is a big case, we do it.
Wow, I never even heard that before. So that is kind of like rehearsing in a little bit.
Well, yeah. I mean, but
Wow.
nobody is told to behave a certain way. But but if a person's natural projection is being impaired by fear and nervousness and depression and anxiety and all the things that's going on with their life, if you can do something that will help minimize that so they can sit there, the bottom line is you need to tell the truth. And if people think they're going to get cute and play fast and loose with the truth, it's always going to come out some way, somehow in a trial. And once the trier of fact, be it jury or judge, determines that witness has not been credible and that their testimony is not believable, then the case, you might as well throw it out the window.
Wow. We have somebody waiting patiently.
Sorry.
That's okay. No, I think our listeners understand that. Good morning. You are on the air. Thank you for being patient, by the way. You're on with John Fuller.
Oh, good morning, Mr. Fuller and Larry. Mr. Fuller, you can just keep talking on and on and on. I just can't stop listening to you.
No, I apologize. I just wanted to finish that point, though, because I thought it was important. But I appreciate your patience.
Oh, yeah. See, a question I have is, it's commonly known that lawyers usually get about a third of the profits from winning a case. Is that ever negotiable with a lawyer to come down off of that amount of money?
I suppose everything is negotiable, but the percentages that are used as standard have been approved by the Florida Supreme Court. And quite frankly, when you look at what all has to be done, the case could take a year or two to try. You're putting your time in it. You are also advancing your money. You will get reimbursed if you make a recovery, but you don't get reimbursed for your out-of-pocket expenses if you don't make a recovery. So you have a lot at stake, and that's the reason that these percentages were established by the court at the levels they were, in order to give people who otherwise couldn't hire a lawyer the ability to get a lawyer and get a good lawyer and have access to the court. Because otherwise, if they were told, well, you just go hire yourself a lawyer, that's what the insurance company has done. Well, John Doe citizen is nowhere, generally, most of us forth are nowhere near financially as powerful as some of the major insurance companies who have a bevy of law firms that work for them on a regular continuing basis. So that's the benefit of the contingency fee contract. Are there some lawyers who will negotiate it down? Yes, but I would caution you to speak to several lawyers and look carefully at them, because there is an old saying, and I'm not being trite, you get what you pay for. And so I would just look at and ask the questions. And when you are asked to sign a contingency fee contract, you must be given at the same time a statement of client's rights, which spell out all the rights. And you ought to ask the person, how long you been doing this? Where'd you go to school? How many cases of this nature have you tried? Will you be the lawyer trying this case, or are you going to farm it out to somebody down the street? Right. Are you board certified? How long have you been board certified? And those are the kind of questions that need to be explored, and people have that right. And, I think that in most every case I've ever seen, the percentages remain standard as set by the Florida Supreme Court. Sometimes you'll see an ad run where somebody will run an ad somewhere and say, well, I'll shave 7 points off of that, or 8 points off of that. And that's their prerogative. And, this is a free country to negotiate. That's a contract. You can do whatever you want to. But the important thing is to find a competent lawyer who's experienced, who believes in your case and that you relate to and have a good working relationship with, because it's a team effort, the client and the lawyer.
And you have another phone call, and we've got enough time probably for this one. Good morning. You're on the air with John Fuller.
Good morning. I have a question for you.
Yes, sir.
I received an injury in the military in 1989, and I was misdiagnosed for 16 years with fibromyalgia, and then I finally threatened the doctor to do an MRI, and they found out I had 3 herniated discs in my neck. My question is, does the VA have any statute of limitations? And I'm sure the doctors that I've seen through the years do have a statute of limitations. Should I go to the VA and file a claim, or should I go through an attorney to file a claim against the VA?
Well, that's a very interesting question. Your first comment is certainly correct, that they are statute of limitations that apply to the medical profession, and it's a shorter statute of limitations than for automobile accidents or other general negligence cases. So you need to be very aware of that, and you need to consult with a lawyer. Making a claim against the VA, I'm not very optimistic, although I will tell you with complete candor, I've never looked into that. Whether or not there is immunity from that, I don't know. There is sovereign immunity. I know certain state-run teaching hospitals have sovereign immunity that cap damages at a very low amount. So I would probably suggest to you that, number one, you should talk with a lawyer who may specialize in military law and medical malpractice laws. I can't give you a more definitive answer of that in a limited time on a call-in radio show. But the time frames you've mentioned are very troubling.
Right. Okay, thank you very much.
Yes, sir. Have a good day and good luck to you.
All right.
Okay,
and
you too. Thank you.
We do have a minute and a half, so are you okay with squeezing in one final call?
I'll try to talk fast or quit at a minute and a half.
Good morning. You're on the air with John Fuller.
Yes, sir. I just have a general question. In the state of Georgia, do security guards at clubs have police powers to place individuals in handcuffs and detain them for the police? That's my question.
Good question. I can give you a quick answer. You need to call a Georgia lawyer. I'm not being facetious, not trying to be disrespectful, but all of those matters are based upon the laws in the state where the matter occurs, and I don't know what Georgia law says about that. I practice only in Florida.
Florida. I'm sorry, I didn't mean to say Georgia. In the state of Florida, do security guards have the
yes, under certain circumstances, they do have, even retail theft, people in retail stores have the right to stop and detain if there's probable cause.
Okay. Thank you for the call. We just out of time. We're up against the clock. I apologize, and it sounds like I'm being rude, but we have these rules. What's your phone number, John?
You can call the office. It's 352-547-4292. Toll-free number 855-534-2565.
All right, thank you. We've got to go to Fox News. Thank you, John.
Yeah, my pleasure. Thank you.
Fox News Radio. I'm Lillian Wu. The president on his 8-day Asia trip. The first stop, Japan.
The president going into a dinner meeting with Japan's prime minister, who was expected to press for a clear statement of U.S. support as Japan faces off with China over disputed islands. The White House has said those islands are covered by the Joint Security Treaty.
Fox News Radio.